Cybersecurity and privacy risks in life sciences transactions.
Hi, welcome everyone. It is my pleasure on behalf of Jones Day and our cybersecurity, privacy, and data protection practice and our healthcare practice, and in particular our health IT practice, to welcome all of you to what we believe is a very timely and interesting topic for all of you on dealing with the rise of cyber risks to life sciences, biotech, and pharma. What we're seeing is really a continuing threat landscape evolving really just by the week with a lot of new reports. It is my pleasure to bring to you some of our leading experts in the field here at the firm who are going to focus on some of the key current trends and issues and hopefully provide you with, we believe, very practical, operational and business-centric advice on how to deal with these issues. First, by laying a foundation of the substantive risks, both compliance and certainly liability issues. It is my pleasure to have on this panel my friend, partner, and colleague, Jennifer Everett, who's a partner in our Washington office. She's one of our leading experts on cybersecurity and data protection, both domestic and globally. And she's helping a lot of our healthcare clients deal with this sort of rising threat. I'm also very delighted to have on the other side of the world, Jörg Kladek, my partner in our Brussels office, one of the world's leading experts on the general data protection regulation, not just the impact and how the industry deals with those regulations, but what does it mean for global operations in the life sciences area. So I'm very delighted for us to have him on the panel today. And lastly, David Kopans, who is off counsel in our Columbus office. He's in our healthcare practice. He lives and breathes these issues for our life sciences clients, both not just in terms of compliance, but in contractual arrangements, both in support of corporate transactions and the implementation and leverage of technology across this entire ecosystem. So we have just a lot of information to share with you. We only have 1 hour to do it, so we're going to jump right in. Let me just give you a brief overview of what we're going to be addressing very quickly in the agenda. First, we're going to sort of give you a baseline of what those threats are, why they're so important, and why we're very focused on communicating these issues with our clients and providing our clients, with some very practical advice on how to deal with these issues, but also understand the complexity of those risks. They are not just domestic. Certainly a number of you have varying types of operations in your business, from research to manufacturing to supply chain. And so the laws that apply vary across multiple jurisdictions. And so we're going to talk a little bit about the international requirement landscape and what does that mean for purposes of dealing with sort of the compliance and liability risks, both in privacy as well as cybersecurity. And in the context of the core topic today was how do we deal with these issues in transactions, whether there are corporate transactions like an acquisition, a divestiture, or some joint venture, or in the context of commercial arrangements where systems, technology leverage, as well as data are key drivers of those relationships. What's the right approach for identifying those issues, risk ranking those issues, and right-sizing the response to those issues in the context of those sort of transactions? And of course, it starts with diligence. Then it moves to contracting and all the issues on those arrangements, and for those post-closing considerations. So we're going to try to touch on all of sort of these issues. Next slide, please. So let's start with what is the threat scenario? Why is this so important, and how that sort of gets implicated in the context of transactions? Next slide, please. So look, I started at the top saying that there are just continuing tactics and evolving tactics by these bad actors, these threat actors that are focusing on identifying and exploiting these vulnerabilities. And that's across all industry segments. And of course, life sciences and pharma, you're not immune to that. In fact, according to recent reports, which started in November of this year, it was reported that a number of large bio manufacturing companies in particular, and some that produce medications and vaccines tied to COVID-19, the pandemic, have been targeted by hackers. There's also some evidence of this increased attacks against groups involved in fighting the COVID-19 pandemic, which includes researchers and pharmaceutical groups developing these vaccines, and against groups involved in the supply chain of making those vaccines available, and how those vaccines are being made available. And according to the BioISAC, which is the Bioeconomy Information Sharing and Analysis Center, some of these threat actors are tied to principally Russia, who are keen on developing sort of malware, such as the tardigrade variant, as part of a ransomware campaign. So this threat continues to evolve. There are reports of major vulnerabilities, such as the Log4j2, which I know many of you who are practicing data protection and cybersecurity are probably dealing with a whole lot right now, which presents a significant risk to the industry, both in terms of business disruption, increased costs, loss of data access, data theft. And this is a very active threat, very significant for all involved in these complex ecosystem. And who are the threat actors? Well, it's organized crime. There appear to be a lot of nation states who are leveraging this behind some of the most recent rash of attacks to our industry. And so the tardigrade malware in particular is problematic because it seems to be specifically tailored to biomanufacturing groups. And we know that from recent reports, the European Medicines Agency, the EMA, the World Health Organization, and the U.S. Department of Health and Human Services all have come under attack during the course of this pandemic, along with a string of hospital systems. So what we want to do is make sure that we are aware of how these sort of key issues of ransom and attacks and any supply risks, and how the potential lack of maturity in managing compliance and managing these risks can cause very significant issues in our industry. And government agencies and our regulators are keen to understanding how the industry is responding to this rising threat, this evolving threat. And it's not just the regulators, it's also private litigants, plaintiffs bar, who are also looking at this and saying, are we doing enough? Are we making the right investments? Are we managing those risks properly? Are we shifting those risks properly? And of course, we see a lot of private litigation in this space as well, certainly after a massive breach. And we see a lot of, civil penalties in a number of jurisdictions, and certainly in Europe. And these can be very significant. As many of you know, under general data protection regulation, we have up to 4% global turnover at risk when it comes to failures to meet safeguards of data under the GDPR. We're seeing a very changing landscape in the cyber insurance area, with both increased premiums and reduced limits. And in some cases, we see some players just leaving the marketplace. So this is a constantly and rapidly evolving space, and it's important to keep abreast of all of these issues, but it's also important to right-size the response, particularly in the context of transactions. So we're going to sort of talk a little bit about what's the right approach. How do we right-size that response in the context of transactions? So let me start, next slide, please, and turn it over to the international landscape with my partner, Jörg Kladek, who's going to walk us through some of these key developments. Jörg?
Thanks very much, Mauricio. So let's turn to the next slide, please. Let's address the elephant in the room often that we have when we're talking compliance, when we're talking also due diligence in context of transactions, when we look at deals, right? Does GDPR apply? How does it apply, if it applies, right? It's often not easy to figure out from the outset. I could make this very simple and say it always applies, right? We can finally almost never find situations where GDPR doesn't apply. And the reason for that is very simple, because GDPR has that effect, that it first of all applies to all companies processing data. Remember, it's a very broad definition, very different from the US framework. What constitutes personal data? It's any data that can be, linked to an individual person or a patient, often in a life science context. And obviously it applies to companies based in Europe. At the same time, it also applies, and this is where it's sometimes tricky or it's not visible on first sight. When you look at compliance, when you're looking at a transaction, you're looking at a target company, right, for review, that it also applies if there's activity coming from companies being based outside of Europe, but then targeting consumers, targeting patients, right, or individuals by certain medical devices, or think about apps, right? There's no operations in Europe. At the same time, obviously data is requested, or data is transferred, and data is obviously used in this context. And in these scenarios, GDPR also applies. So basically, there's almost no escape. GDPR, one or the other, it will apply to a given scenario. So there's very few cases left these days where GDPR does not apply. Which leads us then to look at, next slide, please, on the main issues in terms of healthcare and life science compliance. And I think we put 8 major points here on the slides for you to consider, and I will like to run through them real quick. The number one item is, that any kind of data processing under EU law requires a legal basis. There's some exemptions to that as well, but usually you need to find a legal basis for data processing. What we see in the life science context, when you think of clinical trials, similar situations, that often consent is a legal basis that's considered. There could also be performance of a contract. There could be legitimate interest of business is another legal basis. And the challenge here is that we see in practice also when you look at a transaction, you look at due diligence, often to figure out what's the difference between a data protection consent, what about these informed consent forms that we have in clinical trials, right? How do they relate to each other? Where's the overlap? Where the differences lie. That's one major point to consider. The second point is notice, providing sufficient transparency to individuals that are involved, either via having a medical device situation or an app that's mobile, having provided sufficient information, how data is processed, used for what purposes, how is the data secured, how is it transferred to other countries, right? So having that specifically provided to individuals is a very important compliance factor here, so that individuals understand what's happening with data. And often we see that the information in the life science sector is not specific enough, addressing the types of data that are actually processed and for what purposes. Another point I want to make is with regard to types of data, what we call in Europe pseudonymized data, which we're all familiar with anonymized data, where usually there's no issue when data is fully anonymized, then GDPR doesn't even apply. There's often a misperception when we look at these kind of scenarios together with colleagues in the US specifically, or on the client side, companies looking at data sets and say, well, actually it's de-identified, or it's key coded, or we took away all the identifiers and replaced them, and then there's an argument made, well, it's all anonymized data. Often the target company may say, well, data is anonymized in the context of the trial situation, the context of a medical device situation. And then we say, well, wait a second, is that really the case, right? So there needs to be a closer look often happening that, turns out very, very often that the data has actually been pseudonymized, but it's not anonymized. And what's the difference? The consequence is if data is only pseudonymized, the GDPR still fully applies. So that's a really important element that we see is happening all the time, the misunderstanding what it means if data is pseudonymized versus data being anonymized. Another point here you see on the slide, last point, data protection officers, someone that is responsible for data protection compliance in the organization, can be at the acquiring company, can be at the target company. These kind of people obviously have a lot of knowledge how the business model works, how data is processed in the company. And the challenge we see happening in the M&A context specifically is when we're looking at the life science deal that we have been advising on, is that there is a kind of like an interesting tension sometimes, when and how to involve data protection officers. On the one hand, they can be very helpful, explaining things in terms of compliance, helping deal considerations. At the same time, often data protection officers are not necessarily under the tent, right, so to speak, in terms of a transaction. So there is an issue of when and how you can involve these type of persons in a deal situation. Next slide, please. And so what else is important to remember in the general compliance context, but also for due diligence and M&A, and we will talk about that later more specifically in terms of questions to ask. Let me first go through these examples here. We all know that the US has a framework for data breach notification. We have a similar thing in GDPR in Europe, which is very detailed, very descriptive in terms of a twofold notification obligation to notify regulators and or individuals in case of an incident. And we see in the transactional context that these incidents obviously play an important role to assess risk. So if a target company, for example, has been subject to a number of serious incidents in a given time frame, that's an indicator that security measures may not be appropriate, or that an incident response plan is not in place to capture these kind of events. So that's, more and more, as Mauricio pointed out in the introduction, in the threat scenario, something where, companies taking a look at very closely, what happened in terms of security incidents and what is the compliance framework around these incidents. Impact assessments is another point to mention, where often we're looking at life science technology. We're looking at very, very sophisticated technology that's new in the market, that's going to be deployed, medical devices, new tools, and often data protection impact assessments, even though required under GDPR, have not necessarily been performed. So there's a big gap here to watch out in terms of these requirements. Last but not least, we have international data transfers to consider in two ways. Number one, of course, in terms of compliance, is the house in order? Does, for example, the target company that shares data internationally, globally, have appropriate agreements in place? Is there something missing? Unfortunately, in the last 2 years, these requirements have become more strict, more complex to implement, additional layers, additional case law. So it's really something of concern to have an eye on and make sure that this is buttoned up. Secondly, the transaction or the deal itself, has to make sure that data is actually shared properly between different companies, part of the deal, also with regard to the vendor who may be involved in hosting a data room and so on. So there's two different sides to this to look at that. And then finally, data processing agreements are very important under GDPR. That means, for example, if you look at the CRO that, and has a sponsor as a pharma company, then usually the CRO would be qualified as a processor, and then the pharma company would act as a sponsor, as a data controller. And then GDPR requires in Europe to implement a certain type of agreement in that are very specific in terms of these kind of things that need to be in that kind of relationship documented by contract. What we see now is a trend here on that point, that obviously CROs, as they evolve and develop, often take on additional, I would say, work streams and tasks, which makes it then very challenging to determine, is actually that CRO still a data processor, or could it be having a data controller role? So here there's additional assessments to be made to make sure it's properly reflected in terms of the transactional context. And with that, I hand over to David to talk about the US framework.
Great. Thank you, Jorg. And your comment on CROs, I think also allows for a good transition for us to talk about HIPAA as well, because we certainly are seeing kind of that blurring of lines between the CROs businesses, working with sponsors, but also their kind of increased role with clinical trials and the way that they are interacting with researchers and healthcare providers and the operation of the trials as well. When it comes to HIPAA, I think the first thing well, not the first thing, but one thing I often hear from clients and others is that HIPAA doesn't apply to research, and that's technically true. HIPAA applies to the treatment, the payment, the healthcare operations of covered entities and their business associates under HIPAA. And research isn't one of those activities. But what we often see, and this ties in also with, as we see how CROs and others tend to be operating today, that if you want access to the data held by someone who is subject to HIPAA, whether it's a covered entity or their business associate, or if you are a researcher that is a covered entity, HIPAA will apply to that data, at least in some sense. And so particularly as we see the CROs, extending the types of services being provided and the like, HIPAA has become, I think, a bigger factor in a lot of the transactions that we've been involved in recent years in particular. Now for today, we aren't going to go into a HIPAA 101. We didn't really have time for that today, but we're going to focus on how HIPAA does relate to research, and that tends to inform then our approach to transaction and diligence and otherwise advising clients. That being said, just a few quick points for those of you who may be less familiar with HIPAA. HIPAA applies only to covered entities and their business associates. And for covered entities, it's a very narrow set of entities that would be subject to HIPAA, and that would be health plans like health insurance companies, only certain healthcare providers, so not all healthcare providers are subject to HIPAA, only those that engage in certain electronic transactions, such as say billing insurance and otherwise really kind of interacting with insurers electronically. So for example, if you're dealing with a healthcare practice that is cash pay only and doesn't interact with insurers electronically, it's very possible HIPAA is not something you have to, take into consideration when trying to use or access the data that they might have. Now, covered entities can also be business associates, which are just agents of the covered entities and handling their protected health information. And business associates, as is a common focus of ours in these types of transactions, they have to have a business associate agreement with the covered entity that governs how they process the data, how they use and disclose the data. Now, in terms of the type of data that's subject to HIPAA, HIPAA only applies to protected health information, which is a very specifically defined term. It does not apply to de-identified information, and where it departs from the GDPR, it doesn't apply to pseudonymous data either, subject to some exceptions where there might be a real potential for re-identification, but generally it won't apply. Now, the general rule under HIPAA is that if you're going to use or disclose any protected health information, you have to have an individual's written authorization, but there are plenty of exceptions, and we're going to look briefly at some of the research exceptions in a moment. But some of the common exceptions people rely on to have access to PHI without patient's authorization include treatment, payment, and healthcare operations. Now, in terms of HIPAA in research, I always tell clients, HIPAA defines everything. If there is a word used in HIPAA, there probably is a corresponding definition. And that is true for research, which I have here. But the point with the definition of research is it's not just any kind of research or R&D that a company might do, particularly with any kind of proprietary information. It really has to have that goal of being for generalizable knowledge. And if it really doesn't meet the threshold of this definition, it might, when we're talking about the exceptions under HIPAA, that use or disclosure, that type of research just might not fall into these exceptions. So that's always something when we're doing diligence, when we're looking at how data is being accessed and what it's being used for, we have to ask this question: is it really research under HIPAA? As I mentioned, I hear often that HIPAA doesn't apply to research, which is technically that true statement, because it's just not one of the type of covered functions. Again, not treatment, payment, healthcare operations. And so when any data is being shared with a third party for research purposes, it's also not a business associate function. And so what we often come across, HIPAA sometimes just is not a factor in some of the transactions we look at because maybe the researchers involved, et cetera, are not covered entities. But researchers can be covered entities, particularly, as I mentioned, if they're engaging in those electronic transactions with insurance companies. Even if they have a third party, maybe billing on their behalf or otherwise kind of interacting with insurance, the researcher themselves might be a covered entity and subject to HIPAA. We also run into instances where maybe the organization itself is a covered entity under HIPAA, but HIPAA allows you to set up what's called a hybrid entity, where you can designate some components as being non-covered and not subject to HIPAA. For example, academic medical centers, they might have, be part of a larger university under the same legal entity. And of course, you wouldn't want a whole university being subject to HIPAA when it's just maybe the hospital, for example. And so it's very common to set up these hybrid entities. Where you have a covered entity and they have a research wing, we always need to find out, is it a component that's covered by HIPAA, or has it been kind of set apart as a hybrid entity? Now, another thing that tends to come up is how HIPAA might relate to the common rule. And kind of the guiding point here is that, when a HIPAA authorization is obtained from data subjects and others to allow their data to be shared more easily, the HIPAA authorization that is used focuses on just the use and disclosure of PHI, but the common rule goes to kind of the broader consent of participation in the study. So it wouldn't be sufficient just, if you see a study being done that just has the consent to participation, that wouldn't be enough to get to HIPAA, and a HIPAA authorization wouldn't be enough to cover the consent to participate in the study. So you will always see both of those, and we always look for both of those. One good thing that we see under HIPAA is, while you normally can't combine authorizations with other forms or other consents, the consent to participate in the study is one of the things you can combine a HIPAA authorization for. So as we generally see, authorizations to, informed consent forms to participate in a study always have that HIPAA authorization attached. There are other limits. I'm not going to go into those, but some of these conditions here, HIPAA does impose some limits on authorizations in terms of conditioning them and the like. And so that's always something you want to watch out for. Is there anything in how the authorizations are being used that might run afoul of HIPAA? Now, I mentioned that we were just going to really look at some HIPAA research exceptions today, and there's kind of three big categories here. The first, if you don't have any patient authorizations, the second where you do, and the third where you're dealing with de-identified information. And just starting there really quickly, if you have a set of data that is de-identified, and we work on a lot of transactions and with a lot of life science companies where that's all they need, then if that data is properly de-identified, it's not subject to HIPAA. And going to that middle category where you do have a valid patient authorization, has to meet the HIPAA standards, but anything that the authorization allows in terms of the content of the data and who it can be used and disclosed to will be permitted. The harder one is where you don't have an authorization. That's where the HIPAA has a number of exceptions, including where there's an IRB or a privacy board that can approve the use or access to the data. There's a pretty helpful exception in many cases for any access to PHI for preparation to research. It has quite a few limitations, but I see a lot of clients and a lot of targets and diligence deals that have used this exception in order to help with steady, subject recruitment as well. And then there's a number of other ones. A common one is if you're dealing with what's called a limited data set that's not fully de-identified. It has certain identifiers in it, but just like a business associate with a business associate agreement, you can enter into a data use agreement for research purposes and hand over without a patient's authorization a certain limited set of identifiable information. With that, I'll hand it over to Jennifer.
Thanks, David. Just to sort of, sort of echo what both Jorg and what David would, and saying, it's, as we're thinking about due diligence and mergers and acquisitions, whether we're buyer or the sell side, the important things is just really to kind of understand to what extent, the company, whether the target or whatever is subject to particular laws, and then thinking through carefully, of course, sort of compliance or risk associated with, either failure to comply or, maybe working our way there. And there may be instances, whether outside of the EU or what I call sort of the space between outside of HIPAA, where there may be considerations to think through from a state data privacy law perspective. Now, after the GDPR went into effect in 2018, you really see a number of countries and the US as well taking on or reassessing sort of how we think about sort of comprehensive data privacy laws. And what we have seen over the course of the past couple of years, and this year being no exception, is a panoply of state sort of comprehensive privacy laws being introduced into legislation at different states and passed and enforced. Notably, many of you may be familiar with what is known as the California Consumer Privacy Act, or the CCPA, which came into effect in June of 2018. That law is designed to provide a wide range of rights to consumers, California consumers, for businesses that are subject to the CCPA, and importantly, to provide businesses with particular obligations in terms of providing sort of transparency, obtaining consent in certain circumstances, and responding to, on a timely basis, consumer rights when they apply. The CCPA is due for an upgrade or an update, and that's happening very soon in a theater near you, with the California Privacy Rights Act, the CPRA, which passed in November of last year in 2020, and will come into effect in 2023. The idea there is to provide, again, enhanced consumer rights to individuals, as well as to incorporate key issues like enhanced privacy obligations and thinking through issues that we see, particularly here in Europe, with doing data privacy impact assessments when you're processing a wide range of information, including sensitive information. California isn't sitting alone. In fact, other states, including Virginia and Colorado, have also introduced and passed similar consumer privacy laws. Virginia's just came on the books in March, and Colorado in July, and both of which are expected to go online in 2023. And of course, we continue to monitor what other states are doing as well, introducing similar state legislation. So these states are, while just a handful, are certainly not alone as states start to think carefully about how to manage personal information. Next slide, please. So just as a snippet, when we're thinking through from a diligence perspective, our first thought is here in the US is what information may the target be collecting or processing, like personal information, which anything can be used to identify an individual, name, email addresses, medical history, or like. Now, just because you're processing information, I want to point out, and just as David said, there may be exceptions that may apply with respect to the business. For example, whether in California, Virginia, or Colorado currently, each of these states have broad exceptions really with respect to the collection and use of PHI under HIPAA, or other similar state laws, like for example, in California under the CMIA. So it may be the case that you are engaged in, for example, you may be subject to HIPAA, in which case these laws take perhaps a second step behind in terms of the focus on being HIPAA compliance. Or you may be engaged, for example, in the use of clinical trial data, which is also exempt from state laws. And notably, you could be engaged in the use of anonymized data such that it falls out of privacy laws altogether. However, that's not always the case. And when it is that you are, for example, collecting consumer information online, this may not be subject to HIPAA, or you are collecting employee information alike. It's careful to be thinking about, for example, are you going to be subject to California's law? Is the business that you may be acquiring subject to any of these privacy laws? And notably, if so, then what has the company done to reach compliance or working their way towards in the future, with 2023 being our target date? Next slide. There are other range of privacy laws, many on emerging or key issues that may affect, life sciences or target. For example, data breach notification laws continue to evolve over the course of time in terms of incorporating the type of data that may be protected, for example, the collection use of biometric data. It may be that you're using connected devices or IoTs, and again, California, Oregon, and other states have laws that are designed with respect to technologies that you may have in place, or that the business may be in place that you're carefully reviewing in terms of what connected devices are being using. Again, biometric data and genetic data are continuing to get increased scrutiny from states. California, for example, is the most recent state to pass laws with respect to the processing of genetic information. And Illinois, Texas, and Washington are just a handful of states that are increasing or have been regulating the use of biometric data. So all of this really comes down to what information is being processed in connection to the target company, and to the extent that these laws apply, what compliance obligations, notice, consent, security measures have you thought through in terms of managing risk and a part of a diligence. Next slide. And this really goes to, not just from the privacy compliance side of things, but also thinking through, as Mauricio mentioned earlier, the importance of security on the other end. Protecting personal information and confidential information is really at the forefront as we see of all of these laws, and in particular as we see, for example, in the panoply of cybersecurity incidents that have, caught attention both within the company and the media over the course of the past couple of years, particularly in light of the COVID pandemic. HIPAA is not just with respect with the research and privacy law, but also enforces the security rule as well, and thinks through carefully and to determine whether or not covered entities or business associates have appropriate security controls in with respect to any processing of electric PHI, for example, access controls, vulnerability controls, and training, and can and does enforce in instances where there is a lack of controls in place, in which case it becomes, particularly in a diligence, a careful assessment alongside your IT teams of what companies are doing to secure the information, including third-party assessments of your of the potential security of the information security system you're reviewing. And the GDPR as well has provided some comments on cybersecurity measures as well. right?
Yeah, that's right. So similarly, GDPR has, requirements for having appropriate technical organizational measures for security. It's not very detailed, right? There are principles there and some examples. Encryption is one of them that's important. So obviously, when we're talking integration of data systems, almost at the end of the deal, right, a transaction phase, when you look at that, it's kind of worst case scenario you can imagine if, an incident happens in that context. So obviously looking at security measures, looking how this is done and interpreting the law and taking it a step further to make sure the appropriate measures are covering the processing of the data or the transfer of data is very important in this context. So it's very similar, Jennifer, to what you just outlined on this point.
Indeed, and all these measures are really designed to mitigate the risks of cybersecurity incidents. And I think we could probably do by a show of hands with any of us in terms of deals that we've done recently have had as a part of diligence reviewing cybersecurity incidents that a target company may have experienced over 3 to 5 years. And these are really the type of incidents that we need to think through in terms of, for example, what security controls did they have in place? What have they done to mitigate? What kind of roadmap does the company have in place? And are they currently investigating a potential security incidents that could trigger notification requirements as well? I think, Mauricio, this takes us to a good point as well in terms of thinking about, deals. For example, it's not just the cybersecurity incidents, but really what companies are doing to protect themselves in the first place. And that really goes to the cyber liability insurance as well.
That's absolutely right, Jennifer. And obviously, as you're thinking about the integration issues, it's important that these issues are relevant, not just in the context of an acquisition or a divestiture where you're selling assets and you could expect that the buyer is going to be looking at these issues. Preparation, both as a seller or buyer, is critical. And looking at, particularly where there's been cybersecurity incidents of the past, is looking at the maturity level of the response, how effectively that's been contained, what changes have been made, and whether the company has the proper sort of risk transfer or risk mitigation approach under coverage, under insurance. So I talked about at the top or the introduction of our program, how the insurance industry is really changing in this respect. In fact, the industry has seen really significant claims during the past couple of years, resulting in a very different approach. And we also see a lot of litigation in this area. And we have a very robust insurance recovery practice on cyber. And we see how the law continues to evolve. Some recent decisions sort of expanded the property loss concepts under property insurance with respect to data, where data is no longer available, for example, if it's subject of a ransomware. So we see, cases sort of evolve, and we see the industry evolve. Many companies already have existing protections under traditional policies, the CGL or E&O policies for directors, for example, or a crime policy, where they might be able to get coverage. So it doesn't necessarily have to be specific a cyber policy, although those are very attractive and very popular. But the specific cyber insurance policies, while increasingly common, come with a lot of uncertainty in terms of just the exclusions, whether certain activities or certain compromises or incidents are excluded from war exclusions. Does it cover incident investigations? Does it cover the host of costs associated with an incident response when it comes to forensics or legal fees, notification costs or claims by third parties? And so understanding the coverage is really critically important. And also understanding the level of support that the providers are going to give. And I will say that it's an increasing practice, and it's become far more complicated than it ever used to be for some of the carriers, where they actually will conduct an assessment. They will conduct a underwriting review of the maturity level of your data protection and cybersecurity compliance and risk mitigation approaches. And assess coverage in the context of those approaches. Certainly in the context of deals, there's a different sort of coverage that extends to cyber representations or warranties and has to do with reps and warranty coverage in the context of an M&A transaction. So it's important to start thinking about how the industry is evolving, always looking at the policies that exist, assessing coverage and exclusions on every renewal. I mean, there's always opportunities to look at whether there are any changes need to be made. And in particular, whether you need to designate approved counsel, approved third-party providers that may not necessarily be on the panels of the carrier, but which are important to you as a business, because you may be working with providers that already understand the business, understand the risks to the business, you understand your approach. And so having those providers approved so that they can support you when an event takes place, particularly if you have a cybersecurity breach, is important. And there's different sort of views about the use of the panel structure within the carriers and how important that is to both the insurer and the insured. But certainly looking at all of the sort of issues at every renewal is important. And lastly, it is a common practice to require some business partners, whether they're providers, particular key providers that touch on a lot of data, whether they're a CRO or whether they are an analytics business or they're purely an ITO. It's really important to look at what coverage they have and in fact even require certain coverage in the agreements. Certainly, it's not unusual to specify a requirement for cybersecurity insurance coverage with anywhere between 5 to 10 million, on a per occurrence basis, or in some cases on an aggregate basis, depending on the nature of the relationship and the risk that it presents to the company. So it's really important to think about what insurance requirements you will impose under those sort of arrangements. Next slide, please. Now we're going to sort of quickly go through, and I'm going to throw it over to Jörg on what is the sort of right approach in conducting sort of diligence. One thing I didn't want to mention before Jörg starts, and we sort of talked about how do you deal with these sort of general compliance obligations. It's important not to just think of due diligence as just a check the box exercise, as some kind of rudimentary exercise. It's important for you to be involved in formulating the scope of the diligence. Jörg and the team is going to go through some of the specific questions you want to ask, but think about diligence very early on and contextualize the diligence both to the deal, to the value, to the data. The data may or may not be the driver of value, maybe other areas, but still implicate security, not necessarily privacy. So it's important to think ahead of time. How are you going to map out this process in a transaction? Jörg?
Yeah, sure. So basically, what are next slide, please? What are actually the questions concretely? What should you ask, right, in context of a deal in terms of the due diligence? What is the important questions, right? Here's my favorite top 10. Actually, it's only 9, I think, right on the slide. So, and then we'll talk about Europe a bit, and then also David, Jennifer will talk about the US, and then we have some examples more even specifically to the life science situations that Mauricio just explained. So let's start with the EU real quick here. As I explained, you have to make sense of how does GDPR apply in the context, for example, a target company, right? Equally important, if you're not on the buyer side, if you're on the seller side, you understand, the other side, how does GDPR apply? And if it does, obviously the question is, to what extent is GDPR compliance considered? And often we see a whole range of things, right? How this may have happened in the past. It can be there's almost never a full, perfect, 100% compliance program, but you can have, you see companies with minimum measures, and then you see companies that have done a better job, and then up until companies that have, very thoughtful, holistic approach. So obviously, the more you move towards a more holistic approach that you see in terms of compliance, the better in terms of risk assessment at the end of the day, when you're thinking about, SPA or disclosures or the risk assessment or recommendations in the diligence report. Equally important, looking at policies, procedures, right? A cornerstone for any compliance company should have that. That's a question that's, number 1 or number 2 for sure, including, and here again, making the link to incident response plans. That is not a requirement, for example, in the GDPR explicitly to have such a plan, but obviously in practice, it's very, very much appreciated also from a cyber insurance liability perspective that companies have that properly in place. How to deal with cyber attacks and incidents, as Jennifer has explained earlier. Obviously, there's notices that have to be checked and reviewed. These data protection impact assessments, we often see this has been done in a very rudimentary way, if at all, right? So this is really something that sticks out as often not being there or not being in sufficient form, even though required by GDPR. So that's really something to point out, to have an eye on. Technical organizational measures for security, obviously something you need to find the right people to talk to explain that. Often the protection officer, compliance person will not have the technical detail to explain these measures in context, what they do in terms of security, right? So that's something to watch out for. Similarly, that history of incidents that shows to what extent the company has a handle on incidents and security measures, and also reporting obligations vis-a-vis regulators, any pending communications, any pending investigations, communications with regulators, very important to consider in the due diligence. The question is, the DPO appointed, yes or no? What is the threshold for that? When this has to be done? When it's missing? How can be there a quick fix to do that, and so on. The issue of misunderstanding of pseudonymized data versus anonymized data, I explained earlier today in our session. Very, very important. Lots of calls sometimes just to figure out, what is with this data set? Has it been pseudonymized? Is it fully anonymized? What is actually here happening in terms of data? So that's a very important one. And last but not least, data transfers. Make sure, that transfers are covered, and that, for example, the target company has the appropriate transfer agreements, if that's a legal basis, in place. And not just for the US often, right, but also for Asia. Think about Latin America if required, Africa, other jurisdictions where from a European point of view, that's really, really necessary. And again, it has not become easier to determine, identify that, and to do a proper assessment. It's probably the #1 risk factor right now in your due diligence report. David, Jennifer, on the US side of things, what can we report on that?
Thanks, George. A lot of the questions, at least, can be overlapping in particular, right? Whether we're thinking from a US or from a European or international perspective, or whether we're on the buy or the sell side, to be honest. We want to carefully think through, like, again, what laws are they going to be subject to in the first instance? Even for the US privacy laws, if it's a group company, for example, nonprofits or the joint ventures may be captured by CCPA by virtue of affiliation, because those laws are broad enough, depending on the control and common branding, that they may be captured in the CCPA. Have you done risk assessments? Has the target thought through or brought in a third party to determine, for example, its compliance with the privacy laws, or for HIPAA, from a privacy or even from a cybersecurity perspective in particular? We carefully look at vulnerability assessments, penetration tests to determine what high or medium or low risks or vulnerabilities have been identified, and then what has been done really to mitigate those risks. A lot of times it's a question of what information are you collecting in the first place. It is very hard to protect and even to comply with privacy and cybersecurity laws if you don't know what you have, or the target has, or where they have it in the first place, where they're using it. So has the company thought through what information it's actually collecting, whether from patients, customers, online, employees in the well? So it's a wide range of issues to be thinking through, many of which we've touched on, from the cybersecurity insurance, as well as, for example, for the breach litigation, whether 3 to 5 years, or even longer in the past, if any things that may be happening or investigating in the current standpoint. I won't belabor each bullet point in the interest of time. I think maybe, David, we can focus on really sort of life sciences specific diligence. Of course, we have some overlap between the privacy components and really what our audience may be thinking through as well when they're going through diligence on their own end. David?
Yeah, that's right. Thank you, Jennifer. And I think what a lot of what we've just looked at between the GDPR and the U.S. specific diligence requests, many of the same type of requests would apply across the board, to any transaction dealing with personal information, especially any kind of health related information. But we always run into issues, particularly with life science transactions, where we often see the same type of issues coming up, or there's always novel issues that we have to work through as well. This slide just has a few sample ones that have kind of popped up on a kind of a recurring basis from transaction to transaction. So we thought it'd just be worth highlighting a few today. One of them is subject recruitment, where we're looking at a transaction that involves, maybe it's a CRO, maybe it's someone else that is helping with recruiting subjects for trials. We often run into issues about the methods for reaching out, and we won't get into necessarily all the healthcare compliance issues. There might be some broader issues, but at least in terms of privacy compliance, whether it's HIPAA and the like, there's always issues about how that outreach is occurring, what kind of authorizations and consents have been obtained. where HIPAA applies, I mentioned earlier, there was that preparatory to research exception, which can be really helpful, but even that exception gives a lot more flexibility to where the covered entity may be doing the contacting of potential research subjects, as opposed to maybe a third party, including the researcher if not affiliated with that covered entity. So there's all kinds of potential problems and obstacles if records and the like will be mined in order to kind of come up with a database of potential subjects. Another one with CROs and other vendors, we always have to pay careful close attention to the contractual privacy and security obligations that have been agreed to. We've mentioned a couple of times now, I mean, we're seeing an expanded role of CROs in the industry, beyond just kind of working on behalf of sponsors, but really having a greater role in kind of the research side itself. And so we're seeing a lot more business associate agreements and the like, and needing to take HIPAA to account in a way that necessarily hasn't been the case traditionally. And that ties into our third bullet point here with the business associate relationships. If we come to a transaction and we see services being provided, not just on behalf of the sponsor, but on behalf of the research sites that may be covered entities under HIPAA, are there business associate agreements there? Are they up to date? Do they cover what they need to cover in terms of pure HIPAA compliance, or do they also cover kind of broader issues in terms of liability for data breaches and the like? And I'm talking very much at the moment from kind of a U.S. perspective, and that's my expertise. But obviously the GDPR and others, are things that we have to take into account just as much when we're looking at these relationships. And that, in particular with our final bullet point there, with affiliated healthcare practices, we are seeing, also, of course, there's quite a bit of research being done where you have a research wing and you have a healthcare wing. In some cases, we've seen them literally physically down the hall from each other, blurring of lines, what's happening with those records as well. So always needing to kind of take that into account. So, kind of in sum here, I mean, there are broader questions we'll always get into on transactions, but, we'll see a lot of these kind of targeted questions that need to be considered both ahead of time before the transaction happens, but also, once we're into the transaction and negotiations and diligence, looking for these types of issues.
Thanks, David. One thing I wanted to add to the point that you've made is when you think about the due diligence in this context, you're going to have the general due diligence on cyber and privacy, and particularly dealing with the state level issues, general HIPAA issues. And then you do want to focus on some very specific questions and inquiries with respect to the clinical research side, raising some of these questions. So doing that sort of different level of inquiry, because you're going to likely be talking to different folks with different knowledge and experience within the organization. Then we turn over to Jennifer.
Thanks, Mauricio. One thing I think we were thinking through as well as, once you've done the diligence, then the question then is, what are we thinking about in terms of reps and warranties, whether from a, GDPR or US privacy or HIPAA perspective? David, do you want to walk through some of the key reps and warranties? And you and I actually work together quite often on and in terms of reviewing SPAs and similar agreements.
Yeah, that's right. And again, we're just covering this at a high level today, but given all the different laws we've talked about, the compliance risks, all the considerations, we always approach these transactions wanting to make sure we at least have a baseline of reps and warranties covered, particularly where we're representing the buyer in the transaction. And so, the first thing we'll look for, definitions, are the key definitions there, from a privacy perspective, the data protection laws covering HIPAA, GDPR, important concepts such as personal data information. And then kind of just going down the line here, we want to see reps that are addressing, compliance with law, particularly that there's been no violations of laws. And that often extends beyond just, pure law, but also any contractual obligations, authorization and consents, as well as, both internal and external privacy policies. We want to know that there's no actions, legal actions ongoing, whether it's by the government or other, maybe it's customers or other third parties, that there hasn't been, or that there isn't even a risk of any actions. And if there are, of course, that's where we would look for disclosures and to kind of review what type of litigation or other investigations the target is subject to. Data protection measures, and we talked a little bit about security earlier. We want to understand as part of the transaction the security measures that the target has in place. and to make sure that that is properly documented in terms of the representations in any transaction documents. Data breaches, the same thing. I think, as was made clear earlier in this presentation, almost every transaction we deal with, there's something that's being disclosed. So we want to make sure that representations are properly captured for data breaches as well. And there's many other kind of more standard reps and warranties that we always want to look for about sales of data, that nothing about the transaction will be, a breach of any of these privacy security obligations. And of course, sometimes we have to tailor some reps and warranties depending on what's discovered in the diligence as well.
Thanks. And I think what the last piece here is really just thinking, for cyber and privacy, it doesn't stop at the diligence and review of the purchase or the sales agreement. It really thinks, as well as what happens at closing and then post-closing integration issues. I mean, the key issues that we think about, whether, again, whatever privacy or cybersecurity law is, notice in the event of any particular incident. For example, in the event of a security incident, it could very well be the case that in the course of the deal that there becomes or rises to the top a certain data breach that may require notifications or other sort of investigations to take place. And so including those types of provisions in your closing covenants, as well as Mauricio pointed earlier, the importance of cybersecurity insurance to maintain that, and ensure that insurance policy is at a appropriate level for the data that they're collecting, covers a necessary number of events, and then sort of is obviously of course not going to expire during the course of closing, as well as sort of any sort of other cybersecurity incidents and your no material adverse effects clauses as well. Just in our last minute, post-closing issues, again, thinking through, for example, if there's a TSA, ancillary services agreements, reviewing existing contracts in terms of ensuring that there are appropriate, downflows of necessary privacy and cybersecurity provisions with your service providers. Implementing data transfer mechanisms, which, as Jörg mentioned, are really critical today, in particular in Europe, in terms of moving data outside of Europe to the US, and ensuring those sharing agreements are in place. And then reviewing, updating, and implementing notices, policies, and procedures, and consents in particular. For example, if you're collecting information from patients or other entities or other sensitive information that may require consents for the use of the information in the first place. With that, we're at really the top of the hour. Mauricio, I'll leave it over for you for closing thoughts and any questions that may be lingering while we have time left.
Thanks. I really appreciate it, Jennifer, Jörg, and David, for really a wonderful conversation and discussion. Please move to our next slide. I want to thank all of you for the great discussion. Of course, we've tried to answer questions that have come in through a Q&A in real time. But if anyone has any question, whether specific or general, please feel free to reach out to any of us. We're more than happy to have a conversation with you and have you do a deeper dive on any one of these issues. Again, this is a very complex area. We've really just scratched the surface. Transactions continue to be far more complicated, and we see just a lot more attention, necessary attention, being placed. So we hope to have another program for you in the coming future, so that we continue to address and give you up-to-date information on what we're seeing. So with that, I'd like to close and thank all of you for participating in our conference call today on behalf of Jones Day and our cyber practice, as well as the health care and health IT practice. Thanks, everyone. Have a great day.